It'll catch the table and the.
That's okay. So I'll be out of the picture a lot. That's fine. Anyway, the one thing, let's talk about the mediation process. I mean, this is what I'm going to talk about now for maybe a half an hour. We'll take a lunch break and we'll come back and I'll finish. So these are what I'm going to take you through, and you saw illustrated, at least through caucus. Depending on what your setting is, you know, things may be altered a little bit. One of the things that I do a lot, not here at the center, because there's no time for it, but in private mediations, is I have a preliminary meeting with the parties, not on substance, but to talk about process. To talk a lot of what is covered in the mediator's opening statement with them. So before the actual formal mediation session, I'm answering questions, we're reviewing the process, so then they're actually more prepared when they come to the session, what this is all about, so they can start focusing on it. That is real helpful, I've found, in really in the private sector, actually getting more settlements. Just that step, that you've already started building rapport and trust. Again, that's not, you're not going to do any of that here, and at the center, you know, it's a volunteer program. We have a one-shot deal. You come in fact, in the courtrooms, the parties are thinking that they're before the judge, and they're ready to try their case, and they don't have any idea what mediation is. And the judge says, you know, why don't you try, here's a mediator, why don't you try that, go in the conference room. So your opening statement is really important from that standpoint. You would still, if you have this preliminary meeting, do an opening statement when they're there. And you know, if there's attorneys and parties, you know, you want to bring the parties in as much as possible at that point. You can discuss issues like authority, making sure the right parties are at the table. That's some preliminary information that's helpful to make sure the decision makers are at the table. And other things that could be part of that process or could be part of the very first meeting is in terms of an agreement to mediate. At the center, we don't have one. No one has to sign anything about what they're agreeing to. In the private sector, we usually have some sort of agreement in terms of time out. Okay, we'll just all have lunch the rest of the day, and lunch is arriving early, that's okay. In the private sector, we would actually, especially on issues like confidentiality, and I'm not going to go into it, but what those guidelines are. When we get to the opening statement, these elements are things that are pretty standard issues, but for whatever setting you're in, you may want to vary them. You want to think about all these, you may need to add things. But confidentiality is one, where the parties are actually signing that this is confidential to them, because if you noticed in Margaret's opening statement, she was basically saying it's confidential as far as she's concerned. That doesn't mean the parties aren't going to talk about it. So, you know, there may be some agreements to mediate. In a divorce situation, there may be even a longer agreement just about, you know, just fair disclosure stuff, or a whole bunch of just what the process is, that they've been advised to also consult a lawyer or things like that. So the preliminary meetings can be helpful. Sometimes if you can't get them together, just doing that over the phone is helpful. Again, you know, without getting into much substance, you'll learn some of it, which is important, because then you'll as a mediator start knowing what the key issues are, and maybe what you might ask what major obstacles they have seen, maybe a little negotiation history. All that can be really helpful to the process. But that notwithstanding, what's another part of the process that I don't think was in our notebook, and it's before this as well.
Can I
yes,
ask you a question before
sure.
we go on?
Sure.
I can imagine that it may be kind of touchy or sensitive in trying to decide on which mediator or which mediator company,
Mm-hmm.
where they're located too. Sort of.
For the parties to.
Yeah.
Okay.
You're gonna have two mediators talking with one another, trying to figure out who's going to handle it.
In terms of the parties selecting who the mediator is?
Yeah.
Yeah, that could be handled, that's handled in a lot of different ways. At the, one of the preliminary discussions for the parties is to even mediate. Or should they arbitrate, or how they want to handle it, if they've been unable to negotiate it. And so then if they do make a decision to mediate, okay, then in the private sector, who's their mediator going to be? And they have to agree to that. With large dispute resolution firms, it's easier because they can call and they talk to an intake worker who, you know, says, hey, we got a list of 14 different people, and say, you know, this person might be good. They hand out resumes, references, and the parties can decide who they like. You know, they want a retired judge, they want an attorney mediator, do they want somebody else? But the parties have to agree with that. At the Center for Conflict Resolution, they don't have a choice. And it's free, so they get it for free, but they get who is at the table that day. And, you know, I mean, we have a quality control here and a peer review, and not everyone is let in to be a volunteer after training, so there's some, hopefully, some quality along it, but they don't have a choice. But if they want to pay for it, then they get a choice. In different settings, that may vary. Did that help answer it, or did that not
Yeah,
exactly
well, I
what
would
it
be
was?
a little concerned about a certain allegiance building with one, you know, like, for instance, the company that you work for outside of the center. I mean, if there's one company that's consistently sort of
Well,
using or has a history with.
For example, that is the situation with a lot of the large firms. So there's certain insurance companies that we do a lot of work for, and the key there is disclosure, and that even gets to the partiality disclaimer that I'll talk about. But we'll do that up front, even before the session, so it's not a surprise. So that's usually on the defense side, say in a personal injury case. We'll let the plaintiff's counsel and them know that, hey, you know, we also do a lot of these cases. We don't think it's going to interfere with our impartiality in this case based on what the role of the mediator is, not making any decisions in the case. Do you have a problem with it? Usually there's no problem. In fact, sometimes they prefer it because they figure, oh, I'll have extra knowledge about how they operate that they can tap into. I mean, it's not uncommon. That's the same issue. I guess I'll deal with it right now. The partiality disclaimer in the opening statement, the key there is you saw Margaret do it in terms, I don't know any of you, and that lets people know that you don't have a stake in the outcome. But let's say she knew someone. In my situation, I mediated with the same individuals before. I disclosed that. Again, if you can do it up front, all the better. But no one ever has a problem with it. So what I would say is, you know, I just want to let you know that I mediated a case last month with so-and-so. I don't feel that's going to pose a problem for me in my impartiality. That won't be a problem for me. Will that be a problem for you? Do you have a concern about that? And both of them, do you have a concern about that? Maybe they didn't like me. So that usually is all that needs to be done to take care of it. It's their process. It's voluntary. If they don't want it, they don't have to do it. So they can choose someone else. Yeah.
In arbitration, in the public employment realm, generally, or I've seen this done, I thought it was general practice, where they had parties would get a list of 5 arbitrators and then take turns eliminating
Sure.
one. Now, is it something that's being done with
No.
mediators?
Well, that in particular, I know that's done with the American Arbitration Association, which has historically the leading, because they had arbitration clauses written in all the contracts. That's how they do it, and there's different systems for that. In mediation, and even at the place that I'm at, Jam's End is a little advertisement, we don't do it. I mean, they select one arbitrator usually to handle it, but the parties have to agree with it. They have a panel. They decided to use us. Here's a list of 12 arbitrators. You know, you guys figure out who you want. In mediation, no, it's rarely done. What the sophisticated clients are doing is, okay, again, it's a decision. Do I want to mediate this case? Okay, both sides decide they do. Both sides are thinking, what type of mediator do I want? It's getting that sophisticated now in the large corporate litigation area. Small business, they don't even know what mediation is, so there's not sophistication at all at that level. But in the higher level, they're saying, do I want a facilitative mediator? Do I want an evaluative mediator? On the last day, I'll talk a little bit about those differences. But an evaluative mediator might put out some decisions there. Maybe that's a retired judge who say, well, in my years on the bench, blah, blah, blah. It's not what we're going to be teaching here, and that goes back to the suggestion, so I don't want to dwell on that until the 4th day. Do I, what style mediator do I want? Checking all the references, how many employment discrimination cases have they done, or construction cases, depending on what it is. So they're getting it's getting harder and harder for the mediator without experience to get those type of cases. Is that helpful? Okay. All right, let's move on. What I was going to was in terms of, let's do it over here. Let's talk even before the opening statement about the physical environment. What do you think is important in terms of for mediation to happen most effectively? And we'll write them down. Just some ideas that you would think is important in terms of the physical environment.
Well, it has to be comfortable, I would think.
Okay, comfort. Yep.
No distractions.
Okay. So private.
Neutral, you don't want any controversial artwork on the wall. So,
Okay, but neutral in terms of what's in the room and also location itself, perhaps. Good. Other yeah.
Place for people to wait while you do the call.
Right, and what we are talking about now is in theory, and thank you, because I want to emphasize that. Even here, where we're getting a little cramped in our space, there's waiting rooms and different conference rooms to go in, which makes it, we keep parties separate here when they come in. So one party we put in one room, and then the next party comes, we put them in the waiting room, and then when the mediator is ready, then we bring them together, because we don't know where people are coming from, and we're very aware that something could be violent. So I'm talking about in an ideal situation right now is what we're talking about in theory. Mediation is done everywhere. I mean, we do it in the hallways, we do it on the street in some form or another, so it can be done anywhere. But in theory, I'm going to put that into in this rooms. You already. What other thing might be important? I guess I just
seating.
Huh?
Seating to facilitate.
Okay.
Progress meetings.
And what about the seating then, in terms of?
To facilitate crosstalk, there should be a direct eye contact.
Okay.
And I would probably want to be between the table and the door.
Gosh, haven't you done this before? Let's talk about that, which gets to a couple things. We're talking about neutrality, so the mediator's in the middle. If you have, in fact, in this situation, I just pulled these chairs from the other room, but literally, if I was mediating this case beforehand, I would be sitting in this chair over there, and these two chairs would be for the parties. So there's no difference in what the chairs look like. Again, equal balance. You don't want someone sitting in a nice lounge chair, another one in this stiff chair. As much as possible. Again, would that really matter in this situation? I don't think so, but it's something I always think about, and that's really the whole issue of talking about physical environment is to think about it. Why would you have yourself closest to the door? Because I would too. Okay.
I think the reason would be to present a physical barrier for people attempting to leave.
I think it's more a psychological barrier than a physical one. They have to really, it kind of makes a statement for them to go past you in order to leave, I think.
Absolutely. I always, whenever possible, just for that reason, it's going to take a little extra effort for them to walk out on you.
Yeah, I always flash my American Taekwondo card, my black belt card before I,
I'm going to address that one second. The other reason is, from our perspective at the center, something escalates. Hopefully everyone's trained at the center so they know how to deal with as the conflict level gets higher and higher, that it won't lead to anything violent. But our rule is not to break up the fight, it's to get out the door as fast as you can. So so safety comes into it. Safety is an issue with the physical environment. No guns. Again, we deal with situations where you never know what's going to happen. If someone comes in with an umbrella, maybe we make sure that's not on the table or readily accessible. Hot coffee, as we all have learned, could be millions of dollars worth of.
Have you
Yeah.
ever felt like you were in danger, or have you seen parties try and harm each other in your negotiations, in your mediations?
I personally have not ever felt I'm in danger. I have had one person hit another person. It came out of the blue, and it was because there's three people, a man and a woman and a man, landlord-tenant situation, and he said something about her, and it happened really fast.
Did that end the process?
Actually not, and that would get into a whole lot of ethical issues that were quickly raised in my mind. We've got to save those, so I ask you to forbear on that. But the issues that, what happened, normally that probably would end it. As it turned out, we reached an agreement after dealing with that. What typically the concern might be, the person that was hit, did they feel intimidated by that, and could they really freely enter into an agreement? In that particular situation, my concern was just the opposite. My concern was these people after that situation seemed to be giving in. The woman seemed, and it was really her case, seemed to be giving in more, and my concern was she knew that he was out of line, and maybe she was starting to give in more because of that. And there's a lot of other issues with it. But to answer your question, it's an incredibly small percentage. There have been a couple violent situations, but out of the 12,000 cases that have been done here over the years, it's just a handful. And John would know more about that when he's back. Normally, just so you know, we normally start talking about the legal and ethical issues the first or second day, because a lot of times people really need to know about that. We like John to do it because our executive director, because he has the longest history in a program like this, dealing with that. And John is away this weekend, so I have that on the third day instead. So hopefully we'll be able to be patient.
Brad,
Yeah.
do you have a quick answer too? I mean, why do most people choose
Yes.
this
Oh.
as an alternative?
Oh, to mediation?
Yeah.
Part of that will be in some of those tabs back there, but in terms of, yeah, I have a quick answer. Some of you could actually help me out. I have quick answers, but why do people choose this?
Money.
Less expensive.
Okay, less expensive, less time, the possibility to be empowered to make your own decisions, being able to quote-unquote get a win-win situation. Again, we'll talk about that later. Confidentiality, privacy. I should get out one of my old brochures where I listed them all. Any other reasons? There's other reasons. But I think we'll also find them in there.
Thanks.
But I do want to get back to the process. So in terms of the physical environment, I think we covered most of it. So positioning is important, privacy, comfort if possible. You'd never, in the community mediation anyway, you don't want to leave the parties together in the room alone. Even in a private situation, you want to be aware while you're doing that, because they may start negotiating certain things and then you're not knowing what's going on. There ultimately could be a strategic decision in that setting. But if there's any safety concerns possible, you don't want to do that. You don't want to leave your notes in the room. You noticed Margaret picked them up. I think she did. Anyway, we usually do. And she may talk about this later, but she stepped in between. She took Andy out first. I was sitting here, and she walked over here and escorted Andy out, stepped in between us. Very subtle thing, just to make sure. Did you notice that?
Mhm.
Okay. And then took him out, then came back, and then instead of just escorting me out while he was out, which would be, I think, our natural tendency, she brought him back in and then took me out. Just a little thing to make sure there's no problem there. Again, if it's a real professional setting and you don't have those concerns, then you can be more lax with that. So the concepts early on that you're thinking about is, enhancing communication. So round table is better, probably, maybe not. I'd let people who have studied this know more about that. Which doesn't mean you can't do it here at one of these tables, but at one of these tables, I would sit here and have the parties there, just because it makes it a little more intimate and not as formal. In terms of, and we talked about the mediator in the middle and reducing hostility, and equality of the disputants, I already mentioned a little bit too. Yes?
Do you ever want the mediator to be looked upon as a participant as well, as opposed to the leader of the process?
What do you mean by participant?
Well, if you're at the head of the table, then it could be construed as you're leading the process and all eyes are over there.
Right.
But if you say, like, you're like, well, see, I don't know how you go about doing
Well,
this.
let's
but
say I walked over here during part of it, is that what maybe you're saying?
Well, it just is, like, if you sat with the participants and then maybe just be part of the gang, would you ever want to do that?
There's always exceptions to the general rules, so there may be. For our purposes at this point in time and starting out, no, because of the appearance of impartiality and you know, the balance of power, where are you? And in terms of being a participant, no. I mean, the fundamental thing is that you're controlling the process. You're running the meeting, but it's their substantive negotiation. You're facilitating. The short definition of mediation would be facilitated negotiation. So you would, as a mediator, by definition, not be a participant in the process.
My only fear is that there might be resentment, you know,
Resentment.
from like one or both of the participants, and as opposed to trying to, you know,
Resentment if I'm sitting here and being
Yeah,
neutral?
well, yeah, something like that, or as part of the process.
No, I mean, no, I haven't found that at all. I mean, just the opposite. The resentment could come if one felt that you were siding with one or the other. Now, we're talking about, this is we can get into, and I don't know a lot about it, but we can get into a whole cultural diversity type issues in terms of what's the best even model. I mean, we're talking, quote unquote, an Anglo-American kind of method where it's somebody the parties don't know, you come in. But in most cultures, probably, more cultures than not, the traditional thing is to go to a trusted insider that both parties know. And that, that's a different process than we're talking about. But they still wouldn't be participating either. I mean, they're still looked at as, the heart of this is that impartial person, so.
Well, but not as, it may be looked upon, but not actually doing it. I mean, again, taking the leadership role and saying, okay, you're under my umbrella, you're going to be doing this, you're going to be doing that, as opposed to, okay, let's everybody, get together and, all that kind of thing. I'm not sure if I'm making it clear what I'm trying to say.
I'm not sure either, so we'll probably have to hash it out a little bit, as we go along. Except for to say that, I can, as a mediator, I can do things on how the meeting's being run, which could, we all know the procedures could be such that you can favor one side or the other. But my role is really to try to both, one, remain impartial, and two, not give the appearance of being partial. And that would be the fundamental thing here. And there could be some rare exceptions to that.
But basically, you're like chairing the meeting.
Right.
So your authority is with the process, not with the outcome.
Right. Exactly. Okay. Let's see what's happening here. One quick story, just so the whole physical environment isn't just for the community mediation setting. There was I was co-mediating a 33 party case, 33 litigants, construction matter where there was over 100 people in the room, and I think one woman. So a lot of testosterone in the room. And it was a real subtle thing that I don't think made a difference, but we made sure there was some flowers brought into the room. Who knows, but it just shows that we were thinking about something just to have a little softer edge on all those construction attorneys and parties at the table. So again, something to be aware of. Let me do one quick check in terms of, before I start with the opening statement, because if lunch is ready, we'll just do that now. Hang on.
You brought flowers in for the ladies. What did you bring in for the guys?
Well,
Footballs.
poor guys.
So where do you sit with 33 people?
In the middle, I guess.
Stand.
In the middle of the crossfire, right?
One of the most important things that a mediator can do, and a trainer, is be flexible, go with the flow. So technical difficulty with lunch. So we're going to keep going into opening statement, which is fine.
Let me ask you a question. If 33 people are on a table, or are
100. 100 people,
Well,
not
how
around
do
one
you-
table.
How do you see, well, how do you divide up, okay, the good guys on that side and the bad guys on this side, or?
Oh, judgment.
Yeah.
No judgments there, but physically that was a big thing. There's a bunch, and given the constraints of whatever that environment is at the setting that we were in, we had tables that were a little wider than this, but multiple tables. They had their constituencies, and we set it up though. We put, this company is here, and we put name tags out, so we'd have control of that. We had the main parties, closest to us here, and then relevant parties. There's some minor parties that could be kind of off. So we thought about it. Whatever strategy feels best as a mediator. Okay, let's go into opening statement. If you're coming to mediation for the first time as a participant, what do you think is important to know?
Ground rules.
Okay, ground rules.
What's gonna happen?
Okay, right. You have no idea what this is all about, so you need to learn that. I'm just handing out a checklist. I guess it's the same thing that's up there. But you can use this in your simulations if you want, or any other checklist that you have.
Brad, can we keep the door open?
Yeah. It's also, well, I think it's actually cooler on this side of the room. I can feel it over here flowing. Did I get everybody? Okay. So what you're really leading to is giving some information. What is the process all about and procedures? And that's where all these elements come to. This is verbally the mediator is going to give all this information. Besides verbal information, what else is important?
Just get familiar with one another, introduce yourself.
Okay.
Non-verbal communication is very important.
Okay. And so as a mediator, as a purpose for the mediator that you're in your opening statement, what are you trying to do in terms of that? And what does that mean in actually your nonverbal communication?
Well, I think for me, I would want to try and make people as comfortable as possible.
Okay.
Under the circumstances.
Well, and one of the things that is important to remember in the opening statement is one of the goals to have those couple minutes where you're talking is to let people settle into the room. And these people are in conflict with each other. It's also something to keep in mind that they may hear very little of what you say in your opening statement, and that therefore you may need to repeat that periodically to remind them of what your role is and what's going on. But they do need that time to settle in. Mediation has all sorts of different definitions. You always have to make sure people know what you're talking about. Hopefully you can do that beforehand, but mediation means a lot of different things. A lot of people call mediation certain processes that I would not call mediation. The subtle thing, this is where you're getting at, you're trying immediately to gain their trust. And Michael, this gets to being impartial. Eye contact, nonverbal communication, trying to keep it even. Margaret, I think, did a nice job. I don't know if you can see that, but she was looking back and forth. It can become difficult sometimes. One party may be looking off here and just so out, avoiding the situation, and this person's really engaging you. You still, in a natural tendency, would be started engaging with this person. They're trying to control situations too, and you need to be aware of that. You keep the eye contact going, and hopefully, and if you get really experienced in some things, you can, I'll allude to it, but you can actually paste them back into the table. Don't worry about that now, though. So trust, your tone, rapport, you're all trying to set that up while you're giving the important actual verbal information that you're conveying. And you're giving that appearance of equality and that you're running the meeting. So those are all really important. Let's talk about the content then. It's in the notebook, so I don't want to go into it in detail, but I will just emphasize some things. On the name verification, you need to check who's. You can leave it open a little bit just because it was getting hot. Thanks. Who's at the table? So 4 people come in the room. What's your role here? What's your name? What's your role? Could be their attorney, could be a witness. In terms of these non-primary participants sitting in the room, there's a preference in most of our situations in a community mediation level, have the parties closest to the mediator. I mean, it's their negotiation. They're welcome to have attorneys or other people in the room, but they'll play a secondary role. In a commercial private mediation where they're paying, I don't focus on that as much. I mean, the lawyers are there, they have a role to play, so they may